So today we've got Jen Berman with MZQ Consulting. Sorry, I had to throw out that's the the nickname that came from. So MZQ Consulting. Pleasure to have you on. Scott and I met Jen a couple of years back, and we just were thinking about who would be inspiring as a guest, and we reached out, and she agreed to do this. So I've asked Scott to join us, which every now and then he'll jump in on these things, just because he's got a law background. Jen has a law background, and I figured they'd be talking over my head, but we'll see how this goes. So as always, if you've got questions, use the Q&A function in your Zoom browser. I know there's a chat function as well that sometimes questions sneak in on, but those are tough for me to capture and address. So use the Q&A function, and I'll incorporate those into the conversation as we go. With that, let's get started. Jen?
Hi. Oh, I gotta flip the slides. I think that's what that meant, right?
I think you're in charge of this. Oh, there we go. So there's it. I don't know. You're probably better at introducing yourself than I am. I did my MZQ DPI. So there's a backstory to that. Before we turned everything on, we were talking about the where the name of the company came from, and that's where it started out, and then got reduced down to MZQ. But I'll turn it over to Jen. Let her kind of do a quick introduction and get on to the content here.
All right. Well, thanks so much. I am Jen Berman. I'm the CEO and co-founder of MZQ Consulting. And guilty as charged, I am a lawyer. I practiced employee benefits law at an AmLaw 100 law firm, Venable, for a little over 7 years. Stopped doing that back in 2013, about a year before starting MZQ. To provide benefits compliance services. So we started out in the ACA reporting and tracking business. That was our first area, and have subsequently expanded into sort of all things compliance services. So lots of different areas of expertise. But today we are here to talk about mental health parity, which is an area that I've spent a lot of time and attention on in the past 2 years or so. So we want to spend the next, 45 minutes or so today talking about is compliance with the Mental Health Parity and Addiction Equity Act. And this is a big area that we spent a lot of time I think everybody's been sort of gnashing their teeth over in the past couple of years, but I really want to try to break it down, have a conversation around today. So Heath and Scott are here to kind of keep me honest today. I'd rather not do the webinar thing. We talked about that ahead of time. So while I have some slides here, our goal for our time together is to really have a conversation. So I'd like to sort of kind of give a background on how we've gotten to where we are today, and then dig into really 2 areas. So we have not spent a lot of time or attention as an industry in the past year or 2 talking about the quantitative treatment limitation rules. So I'm going to start there and talk about what those are, how they're calculated. It's interesting. It's actually a mathematical analysis that really focuses on claims and historical claims detail. So I'll explain what that is. Then we'll talk about NQTLs and the NQTL requirement, the comparative analysis that is required under the CAA. And then we'll talk about how to stay compliant, the new proposed regulations. And I've got Q&A sort of at the end there, but we're gonna have a conversation this whole time. So please don't hesitate, throw questions into that Q&A box. We're gonna do everything we can to keep this as conversational as possible the whole way through. It's sort of our agenda for the day. All right, so what is the history of mental health parity? It is not new law. I think that's the most important thing that I can say. Even though we've been talking about it a lot over the past 2 years, this is really nothing new. So the original Mental Health Parity Act passed all the way back in 1996, right around the same time as HIPAA. So this is definitely not new. And for the first decade or so, it was something that sort of got renewed every couple of years. So I can remember when I first started to practice, there was always this question of like, is it going to get renewed? Isn't it going to get renewed? What's happening with mental health parity every couple of years? Until 2008, when the current form of the statute passed in the form of the Mental Health Parity and Addiction Equity Act. And then in 2010, we got the ACA, and that sort of expanded the rules to apply to pretty much all plans. There's one sort of type of exempted plan. I'll point that out in just a second. And then in 2013, we got the current version of the regulations that we are operating under. There is a new proposed regulation that came out earlier this summer. So I'll talk about that a little bit in a few minutes. And then it wasn't until 2021 with CAA, sort of the gift that keeps on giving, that we got the newest requirements, which are this NQTL analysis, which I call the congressionally mandated book report. But the 2021 law doesn't actually create new rules around mental health parity. What it does is to require that plan sponsors document how they are complying with existing law. So that's kind of different. It's not, okay, now there is a new mental health parity law. It is, okay, now there's a new fiduciary obligation to document how you are complying with existing law. Okay, so not new law, just a new requirement to document how you're complying with law that already exists. All right. So who is subject to these rules? Almost all plans. Group health plans and health insurance issuers offering coverage in the group markets and the individual markets, whether they are subject to ERISA or not. So this is not just an ERISA thing, this is an everybody thing. With this one little kind of funny exempt group, which is small group self-funded plans. Why? That's like a complicated set of rules having to do with like jurisdictional issues and stuff like that. I don't think that there's any intention for there to be an exemption for small group self-funded plans. It's just kind of how the law has played out to this point. And to be quite honest with you, I think that if we end up seeing a lot of folks taking advantage of that exemption, that you'll end up seeing that hole plugged pretty quickly. But it just happens to be that at the moment, self-administered and small group self-funded plans are exempt. But that's where we are at the moment. All right. So when we get into how does this stuff work, one of the first questions that people ask me is mental health benefits and medical and surgical benefits are not the same, Jen. How on earth does the government expect for these things to be done equally or in parity, or for these things to be provided in parity? And I'll break down in more detail exactly how that whole thing works in just a second. But the first thing to know is that there is some semblance of order to this. It's not super well ordered, but there is some categorization to it all. And the way that categorization works is that the types of benefits that we're looking at get categorized before we start comparing mental health, or MH-SUD, as we call it in the business, so mental health substance use disorder benefits, to med-surg benefits, medical and surgical benefits. And so before we start comparing them, we break them up into 6 or 8 categories, depending on how we look at it. And so the big 6 for these purposes are inpatient and outpatient, in and out of network, emergency care, and prescription drug. So those are the 6 buckets. And so before we start any comparison between mental health, substance use disorder, and med-surg, we break everything up into those 6 buckets. And then within the world of outpatient benefits, there's a further subcategorization that can be done between office visits and other, right? So we're not going to treat office visits as the same as, say, outpatient radiology. So there's some additional subcategorization there. So before we start comparing anything, you break things up into those 8 categories. Following so far? I mean, this is like the world's most fun and exciting, I know. All right, okay. You're smiling, I know. This is really fun, but you know, we got to get here before we can get to where we need to go. So, all right. Now that we have our 6 categories, or our 8 categories, we got to look at things in 2 big types, or 2 big buckets, and those are quantitative and non-quantitative. So the quantitative types, we thought originally that these were going to be easy and that we could just like look at a summary of benefits and say if our deductibles match, if our copays match, if our coinsurance matches between medical and mental health, we're going to be fine. We got the same deductible, we got the same copay, we got the same coinsurance. They match, great, we're in parity, right? It was so easy. I thought it was that easy. That's how I checked it for like the first 10 years while I was busy implementing the ACA. Unfortunately, I was woefully wrong and gave a lot of bad legal advice during that time period. I will admit it. I can wear the dunce hat with plenty of my fellow ERISA lawyers because we were all giving bad advice at that point. My only defense is I was really, really busy implementing other elements of the ACA, and apparently I didn't actually read those final regs that I referenced before because that was just absolutely not what they said. So what they actually said was that you had to do an extraordinarily complicated mathematical determination to see if you were meeting the quantitative treatment limitation rules. And what those said was that a QTL was a limitation on benefits represented in some sort of numerical manner. And examples of those could be things like restrictions on the number of visits, day limits, deductibles, copays, annual and lifetime caps, which we don't really worry about as much anymore because those were prohibited under the ACA. And that what you had to do was look at actual claims data and see whether or not, based on the actual dollars spent in each of these categories, first, if a type of QTL applied to substantially all of the medical and surgical benefits in a given category. So does a deductible apply to substantially all benefits, let's call them inpatient out-of-network benefits? So I would have to look at all the dollars in claims that could have been spent to which a deductible could apply. Not to which the deductible did apply, but to which the deductible could have applied. Every single claim, maybe I'm looking at a look back here, the deductible could have applied to. Did it apply to at least 67% of all of the claims in the medical and surgical category? And if it could have applied to at least 67% of the claims, then and only then would I be allowed to apply a deductible to those mental health substance use disorder claims in that category. Crazy, right? Scott.
Yeah, this is interesting. Two questions. I mean, one's kind of a stupid question, but I'm really good at those. But if a plan doesn't cover mental health, is this just not an issue, or is there still compliance relating? I mean, what?
So, no, it's a great question. It's not a stupid question at all. Theoretically, this is not an issue if the plan doesn't cover mental health. However, there's an argument to be made under these rules that the plan has to cover mental health.
Really?
Really. So you could read these rules to basically say that there is no way to actually have a plan that does not cover mental health. And I know that there are lots of plans out there, I've written them, by the way,
right,
that have no mental health benefit in them. However, the preventive care rules require you to cover things like tobacco cessation, which means you are providing substance use disorder benefits, which then, if you follow the ramifications of that all the way through certain rules, would require you to provide mental health benefits. That is a pretty aggressive argument, but it is a concern amongst some in the ERISA bar that theoretically, and this is an aggressive position, all of those plans that provide no mental health benefits are out of compliance. I don't take that position. I don't believe that to be the case. I think you can still have plans that provide zero mental health benefits. And if there are no mental health benefits, then these rules do not apply. But there is an argument to be made that you have to provide mental health benefits because preventive care includes certain substance use disorder benefits.
Gotcha. And so what do you, like, for your clients that, are completing these analyses, what do you see as the kind of their biggest obstacle with QTLs?
That they're not doing the analysis. I mean, is the biggest thing. I think that the biggest obstacle for the ones that are doing it is that they have put QTLs on very limited subcategories of things like they'll have certain types of limitations on like certain types of rehab visits, or the biggest ones will be in the sort of PT, OT, speech therapy type categories and stuff like that. And that will be the most common categories where we'll have to say, you're going to have to remove your QTLs where they don't hit it. Usually they'll be fine in the out-of-pocket max deductible co-insurance categories. But it's the visit limit categories that they get into trouble with.
Okay.
Or the copays that don't apply to everything.
Okay.
Sort of the subcategory copayments, something that doesn't apply across the board.
Gotcha. Thank you,
Jennifer. We got a couple questions that are coming in here. If ACA says that the items are zero copay, does that affect the 2/3 rule?
Yes, it does affect the 2/3 rule, because the zero copay items drive down the mathematics on this, and it can make it hard in certain cases. So those zero copay items go into the calculations and drive things down. So if you have a plan with sort of low utilization for things outside of the zero copay items, it can certainly skew the calculations when we go and do them. Just really depends on the experience of the plan.
Okay. And then are fully insured plans able to rely on a carrier for the reporting?
Yes. So for most of this, and what we're going to talk about in the NQTLs in a few minutes, the carriers are generally the ones who are going to be doing the mental health parity analysis. And for fully insured plans, we recommend that the plan sponsor document their request to the carriers to make sure that they are doing this. And different carriers are, first of all, they're responsible to their state regulators for making sure that they do this. As plan sponsors in a fully insured plan, you still have some level of responsibility around this, but you're not in a position to have access to the information. So my recommendation is always that you are documenting the request to demonstrate that you are, being a good fiduciary.
Okay. And then Marion has one that she's requested to hold to the end. So at her request, I'm going to just hold on to that one, so ignore it, but we'll hit it up at the end of this thing. But another one just came in. Can a self-funded plan cover mental health but exclude substance abuse treatment?
They cannot. They're coupled for purposes of the rules. It's mental health and substance use disorder. So you can't have one without the other.
Okay. All right. That's the current question list.
So I am not going to keep explaining these QTL rules in detail, because my main takeaway, and we can get into the details here. You can reach out to the team at MCQ at any time if you want to go deep into the math here. Our algorithms, I had to hire a PhD mathematician, quite frankly, to do this math, because it's hard. Shouldn't be this hard, but it makes my brain hurt. The point is that this is heavy math. Like heavy math based on claims data, not looking at a summary of benefits and making sure that the benefit matches, right? And for years, we all kind of thought that it was looking at the summary of benefits and making sure the benefit matched. Myself included. And I was wrong. And I'm willing to admit when I am wrong. All right. That being said, NQTLs have been sort of the topic of much conversation since the CAA passed. And those are the non-numerical limitations on benefits that can keep folks from sort of getting access to care. And sort of the standard, the most obvious first example that everybody gives is prior authorization. But it can be much broader than that. It can be things like how a network is formed and what the standards are for folks getting into the network. It can be out-of-network reimbursement rates. You guys don't know anything about those, do you? No, I didn't think so. No, okay. Formulary design and adequacy on the PBM side, all, really anything that impacts an individual's ability to access their coverage that isn't that sort of numerical plan design stuff can be an NQTL. And the CAA has sort of an express prescription in it that says, all right, plan sponsor, you're a fiduciary, and you must complete an analysis that details all of the NQTLs that you have under your plan, how the plan handles those NQTLs, what factors and standards you're using to apply those, how that works operationally, what specific data applies under your specific plan, and then goes and applies a comparison to how that works both in writing and in operations as between mental health, substance use disorder, and in operations for each NQTL. And by the way, the average plan, we've been doing this now for a couple of years at MZQ, has somewhere between 15 and 20 NQTLs in it, and then makes specific findings and conclusions with respect to each NQTL. All right, so that's what's new under the CAA. Not the law itself, but the requirement to do the analysis.
Does that put them into compliance, getting the report?
Getting the report puts the plan into compliance with respect to the requirement to write the report.
Mm-hmm.
Right? So there's two different things going on. There's a requirement to have a report, and then there's a requirement to follow the Mental Health Parity Act. So lots of the reports say things like, we can't determine if we're in compliance with respect to this requirement or that requirement, or maybe we're not in compliance with respect to this one or that one. But it puts you into compliance with respect to the requirement to have a report.
Gotcha.
Yeah, that's really the rub. So the actual process of getting the report done starts by collecting and reviewing the plan documentation. And then you have to look at all of these different NQTLs and what factors and evidentiary standards there are. And then you go through the process of comparing each of them. And you do that that's the written analysis piece. So as we break that down, the documentation in writing that you end up looking at is things like plan guidelines, plan claims processing policies and procedures, internal standards for processing of benefits. And this is coming from, for the average self-funded plan, multiple sources. TPAs, medical management vendors, network administrators, PBMs, lots and lots of different places. And it's not easy to collect it all, right? And that's why this has become such a difficult process for plan sponsors. The factors and evidentiary standards the Department of Labor is looking for are not necessarily things that have been traditionally documented, not necessarily, I'm just going to go so far as to say, have not been historically documented because it simply wasn't a requirement before. But the things that we are looking at are things like published or internal standards, claims analysis, medical expert reviews, federal and state requirements, NIAC standards, internal market analyses. I mean, there's all sorts of things that are used to make these determinations as to how a plan is administered for these purposes that go into these written analyses as to how the plan is operated in writing. And then we're comparing which standards are used when you're making determinations for medical and surgical claims versus which standards are used when you're making them for mental health and substance use disorder claims. And you want to come to a determination in order to demonstrate parity that those standards are comparable. They're often not the same, but at least that they are comparable. All right. And then that's just the written part, right? Then you have to show that in addition to what's in writing, that we're actually following the same concepts in operation also. So you've got to prove both that our policies in writing are comparable and that the way that we actually do it is comparable too, which requires looking at data, and we can look at the sort of the aggregate plan data, but we can't look at book of business level data. And the rules are very specific that book of business level data doesn't do it. It has to be plan level data. And it's got to be at the NQTL by NQTL level data. This is really hard to do. So here's the challenges. Nobody built their business or their systems with this in mind. So the data is not tracked in a format that's designed to do this. And we've got to have this plan specific data. So the vendors, like, they don't have necessarily the data that plan sponsors are asking for or that they need or that we're looking for to do this. And it's not that vendors are necessarily like bad actors or choosing to be difficult or don't want to help. It's that they actually don't have this. And so now we're a couple of years into this and we're still struggling as an industry and, as a, an ecosystem really to figure out how to get where we all need to be to come into compliance with these rules. And it's simply not easy. So I would say that 97% of the reports that MZQ has issued to date have at least one, but probably, many of the conclusions that we've drawn are inconclusive, which is backed up by the Department of Labor's reports to Congress, where they've yet to find any plan to be in full compliance of what they were looking for. Because what they're looking for is not something that people knew they were going to be looking for before they started looking. So if you don't know people are going to go looking, we didn't have a chance to prepare. And so now the industry is trying to catch it.
Wow.
So what are the consequences of failure here? There is a DOL audit program in place. It is active. I've been involved in audit programs. There are non-compliance determinations. The DOL will come in and make you fix your plan. But what the DOL is really most focused on right now is active violations of mental health parity, and employers who are not going through the active process of doing the thing, right? So ERISA is all about process and sort of creating these reports, right? So if you think about it, what's changed here is there's a requirement to document and to show how you're complying with the NQTL rules and with mental health parity. And what we have found is folks have started to do it is we have no way to demonstrate how we are complying with mental health parity. Going through the process, our team at MZQ has found lots of times, more often than not, we found that we can't demonstrate how we are complying. A decent amount of the time, we found places where people aren't in full compliance and we can make recommendations for things to get better. And a decent amount of the time, we find places where people are in compliance. Almost all of the time, the exercise makes plans better. So I believe at least that is the point. And so the entire collective exercise is making plans better. And certainly the experience that we have had when we are involved in working with the DOL is, and this is always my advice to plans, to be cautious when working with the DOL, cautious but cooperative, right? And if you are cautious but cooperative, usually things work out okay.
Yeah.
I don't worry so much about what goes wrong. People are like, what's the government going to do with me? Well, the worst that the DOL really has in its quiver right now is public shaming. They are trying to get more penalties. There's $100 per person per day theoretical penalty, but they're also trying to get more enforcement authority. The worst thing that can happen right now is plan participants have private rights of action. under ERISA and mental health parity. That is the biggest concern here, and the number one reason to engage in this exercise.
Are you seeing has there been any activity in that world?
There are the beginnings of rumblings. There are some plaintiffs' attorneys who are starting to try to coalesce groups around it, and particularly there are some big name employers that you're starting to see activity around. I've seen some plaintiffs' attorneys say, if you work for X employer, call us type stuff starting to happen.
Gotcha. Yeah.
It's starting to happen, and then there's the potential for future fines. So we're starting to see that, but we haven't gotten quite all the way there yet.
Are you seeing
so
I'm sorry, Jen. Do you have any specific benefit scenarios that you've seen the DOL focus on with their audits?
Yeah, there are a few that they are really, really grumpy about. Limitations on ABA therapy is a huge one for autism treatment. Methadone treatments. There are plans that have restrictions on access to methadone. That's a big one that they have problems with. There's a lot of attention around network adequacy and how networks are defined. There is still a big area of concern. Concurrent review is a big area. So those are a few of the bigger ones.
Okay. Thank you.
Yep.
Hey, Jennifer, we're about halfway through here, and I got a pretty good bag of questions that are in place.
Yeah. So I got one more thing I want to hit, and then I'm going to open it up for questions for the rest of the time, I think.
Okay.
If that works. All right.
Sure.
So last thing I want to hit, and then we are all questions for the rest of the conversation. Last two pieces are the CAA of 2023, which is another CAA, because we like CAAs around here, is expanded these rules. I mentioned that it applies to pretty much everybody these days, except for those small group self-funded plans. Expanded this to apply to governmental plans. There used to be an opt-out for governmental plans, and it does not anymore. So non-federal governmental plans are now subject to this. And then my last planned remark, and then we can chat about this until the end of our hour, is that there is a new proposed rule. The comment period actually, I believe, just ended maybe yesterday or today. The proposed regulations are a little wacky. They're all over the place, but we will see. There's a lot more coming in this area. So that is it for my planned remarks, and it does seem like we got lots of questions coming in. So let's do it, Heath.
All right. Well, we're gonna have a pretty good time frame to get some questions in. So you guys, if you have things that are on your mind or that Jen made you think about, type them into the Q&A portal here, and we'll build them into the rest of this half hour. So there's one that it looks like I missed early on in this that came in on the chat side. So would you suppose that one area of non-compliance might be formulary tiering for MH drugs? And then broken out of this, we are seeing generics in T3 and T4 so often.
I'm sorry, tell me the second part.
It was just a comment. We see generics in T3 and T4 so often! Exclamation point.
So, it's interesting. We have our own tests that we do here on formulary. We don't typically see a lot of problems with the formulary design on MH drugs. So it'd be interesting to see what the concern is there. Prescription drug seems to be the area that we see the least problems in when we actually sit down to do the analysis. It'd be interesting to understand a little bit more about that. But of the 6 categories, prescription drug is the one that we see the least problems in.
Okay. All right, so I'm going to Marion's question here. She put this in early as well. Hi, Marion. Good to see you joining here. We are in receipt of several $1 million plus events for treatment of autism. The provider is out of network. It is a ABA Center of America. Jen, are you familiar with them? Any insights about the appropriate way to review autism claims specifically? Are there national standards to measure progress?
That is interesting. I am not familiar with that. I mean, I am familiar with. No, I am not familiar with that particular provider, nor am I familiar with claims running that high for autism. So most of the autism sort of claims analysis that I've seen is not running anything close to that high. So I'd be interested in sort of looking at that. So there is no limitation on the ability to have medical management, like reasonable medical management and things like that with respect to autism. The place that we see autism being problematic is when there are exclusions or prior authorization requirements that call out autism specifically. If you treat autism the same way that you treat other benefits under your plan, it's okay. The problem is when you sort of call it out specially. So it'd be interesting to look into that in more detail. I don't know what my camera seems to have had. I apologize. Now it seems to be following me and losing its mind, guys. Well, I'll do my very best.
It adds a little. It's interesting.
I don't know what happened to it.
It's like a Hollywood effect.
Something very special is happening with it. I'm going to try to stay as still as I possibly can. Yeah.
It's fine. It's not that bad on our end, at least.
Yeah.
All right. Have you had any plans audited, reviewed that have had this done in past?
I have not had a plan that has done this and where we have found that every single piece of it is in full compliance with mental health parity. But I don't look at this as an exercise, as a pass-fail exam. So the way that I suggested that folks think about this is much more like a home inspection than a pass-fail exam, right? You never go into getting you don't go to buy a house and expect that the home inspector is not going to find anything wrong. And in fact, if you ever went and hired a home inspector and they gave you a passing report and came back with nothing wrong with that house, you would go and hire a new home inspector, right? Like you'd be like, something is wrong with that person. So the way that I ask people to think about this is much more like that. Like the purpose of this exercise is to understand where the plan is and what the opportunities for improvement are. And it's, in fact, we are not at a place as a industry where the data yet exists to come to a conclusion that anybody is in full compliance with the Mental Health Parity Act. I mean, the Department of Labor's reports to Congress on that tell us that. So that should not be the expectation going in to any mental health parity, non-quantitative treatment limitation analysis. So it's not a pass-fail test. It's an inspection to tell you where you are and where the areas for improvement are.
Okay. Having had my house recently inspected, they're pretty good at finding things. So. Have you?
So you just hope that you don't need a new roof or a foundation, and then there are a foundation, right?
we sold that house back in February, but had to do a little work on the. Actually, it was a part of the roof. It allowed some seepage under the roof line that caused some mold and stuff. So they found it. We got it fixed. All right, back to you guys here. Do telehealth add on benefits that offer limited medical services to all ages, but only offer MH services individuals over 13 years old because parity issues?
Yes, a telehealth benefit that offers medical benefits to all ages, but mental health to only over age 13 would absolutely cause a parity issue. It would be a scope of service NQTL, and it would be a parity problem.
Okay, so this one, maybe a question, maybe a statement. It came in about 9:30 a.m. Pacific time, so the bottom of the hour. I'm not sure which specific slide it was referencing, but it said, "Isn't that their job to find mistakes? They want to find errors." And I think that's kind of what you were just referencing around the home inspection, but I'll let you answer that.
Yeah, I'm going to assume that was similar to my home inspection issue. We're just going to go with it as being a home inspection.
Just going to go with it, yeah.
Yeah.
Without further clarification, we're going to make that assumption. Okay, so just to confirm, if a group has HSA and 2 PPO plans, we need to do 3 analysis?
No. So if we're doing an NQTL analysis and that we're dealing with different plan options, we do not need to do 3 distinct analyses if the NQTLs are essentially the same. That can be handled in one analysis.
Okay. Can the fee for the analysis be paid from plan assets?
Yeah, I actually believe that the fee for an NQTL analysis or a QTL analysis, any of the fees in this regard, could be paid for plan assets. So this is a fiduciary obligation of the plan sponsor, and I think that would be an appropriate use of plan assets.
Okay. What do you think about gender affirming benefits and mental health parity? Question. What if a group wants to not offer the surgical benefit? Would that fail the NQTL analysis?
It's an excellent question, and one that has been a topic of much debate. So gender affirming benefits are, so I believe that the psychological treatment for gender identity or gender dysphoria would be covered as a mental health benefit, and would need to be covered, and then an exclusion there would be a problem under mental health parity. There is sort of an active debate relative to the surgery itself, and I think that is unsettled law at this point.
Okay. So this one, Jen, is about getting your contact information. You want to rattle that off real quick for anyone listening?
Yeah, absolutely. So my email, which I don't think is on the slide, so I'm not going to throw that back up, but my email address is just Jen, Jen, at mzqconsulting.com.
Okay. How quickly is a plan required to comply once failures/issues are identified?
There is a very prescribed set of rules, timing rules under the DOL's administrative procedures, and it is very, very quick, depending on sort of where you are in that process. It can be 60, 45 days, depending on sort of where you are in the process. So the short answer is faster than you will be able to get your act together. So you need to do it before the DOL knocks on your door.
If your plan notices to have X areas of improvement needed, is the group required to make these changes? Question mark. What is simply don't make the changes and keep the plan as is?
Well, that depends on if the conversation is with an auditor, like a company, an external company that you've hired to do it, or the Department of Labor. If it is a third-party auditor, it's kind of, the group has some level of discretion as the plan fiduciary to decide if they want to follow the advice of a vendor that they've hired to do this or not. If it's the DOL, there is a parade of horribles. But ultimately, they have the authority to make you or penalize you, or they can shame you and all the rest of it. They can also, and this is, I would say, probably the biggest risk that we have not talked about, while they have limited penalty authority under the Mental Health Parity Act. The absolute worst thing that they can do, and the thing that they do when they get really mad at you, is refer you to all of their friends. that have penalty authority to make your life miserable in other capacities. And I have seen them do it. So if they get mad at you and they don't have penalty authority, which they don't under mental health parity, they send you to the wage and hour people, or they call the IRS on you, or they do all sorts of other things when they get mad at you. And that is the worst thing that they can do to you. And I have absolutely seen them do it when they get really mad at somebody. But they eat lunch with the guy over there. Don't get a DOL agent mad at you.
Sounds like the middle school mean kids or something. Yeah, picking on you.
Well, there's a lot of value in being nice.
Yeah. Do you offer any type of guarantee with your analysis?
Yes, we do stand behind our analysis and work with any group that has like a subsequent DOL audit and things like that.
All right. So this question starts off by saying it's a little off topic, but can you give an update on gag clause prohibition compliance attestations? It's a big word for me. I've listened to her comments on podcast recorded on October 4th and wondering if anything has developed since then.
Do we have to? Yes, of course I can. Yeah. So where we are in gag clauses is it does not look like at the moment, and anything can change, there's going to be any sort of extension or regulatory relief relative to the gag clause requirements. I'm still advising self-funded plans not to file a gag clause attestation unless they are confident that they have no gag clauses. And I don't have a high degree of confidence that most of my self-funded plan clients don't have gag clauses.
Jen, can you, just for those that didn't listen to your podcast, can you give a little bit of background on what that is?
I can, Scott. Thank you for asking.
Yeah.
All right. So gag clauses are provisions in contracts that a plan might have with a TPA or network service provider that would restrict a plan's ability to access, or a participant or beneficiary in that plan's ability to access information about pricing under the plan, pricing or quality information. They became illegal as a result of the CAA. And since December 27th of 2020, plan sponsors have been prohibited from entering into any provision in a contract that would restrict the ability of that plan to access that information. There is a requirement that plans attest to CMS by no later than December 31st of this year that they have not entered into any contractual provision directly or indirectly since December 27th of 2020 with a gag clause in it. The issue, and so in the fully insured and for the most part the level funded market, it would appear that carriers and TPAs in those two markets, so fully insured and level funded, are for the most part handling that. In the self-funded market, while TPAs could do this on behalf of their groups, most aren't, because in most cases they really can't, because you don't know exactly what contracts those groups may have entered into. Mm-hmm. And the way that it's structured, you kind of can only go in and attest that, yes, this is the case, we haven't done this. The problem is most plan sponsors are not necessarily in the position to know that none of these contracts exist. They probably can figure out what contracts they have signed, but that involves a pretty substantial contractual analysis. They really don't know what contracts may exist out there binding them indirectly, though. And to go and make this attestation to CMS when they're not party to all of those contracts is a pretty heavy ask. MZQ will be doing our own webinar on this topic, probably. We will be, for sure, in the next 2 weeks. We're going to be putting out some materials on it within the next week or so. At this point, my recommendation is don't file this if you don't know it to be true. Yes, there is a requirement that an attestation be filed. However, it is, if you are not sure that you can attest to it, do not attest to it.
Yeah.
You should not attest to things that you do not know to be factually correct. That is bad. Don't tell the government something you don't know to be true.
Hey, how can people listen to your podcast?
You know what? We are working on those details, and if you guys are amenable, we would love to send that information over to you. And if you could share that with this group, that would be fabulous.
We'd be happy to. Yeah,
that'd be great. Thank you.
Mm-hmm.
All right. Well, it looks like some of these questions may be under the gag clause now. So should plans not attest for the gag clause? Thus, it is inferred that there are gag clauses.
I don't think that not attesting means that there is a gag clause. I think that, I mean, you just shouldn't attest to something that you're not certain of yet. It is where we are. And I mean, ideally, and we're working through, and we will again have this presentation finalized within the next, week or two, and we will do our own presentation on it. You should go ahead and do a thorough sort of workup on it. Ideally, you would be able to review all of the agreements and determine that there are no gag clauses in a test. The problem is that under existing guidance, gag clauses can be direct or indirect. And so a plan sponsor can review any contract that they have signed directly, but to the extent that a gag clause could exist in a contract that binds that plan sponsor indirectly, they don't have access to that contract. So you can't sign an attestation that could bind you indirectly when you haven't seen the contract. So it doesn't mean that you're saying that you have it. It just means you're saying you can't do it.
Right. What do you think the solution is here? I mean, are plan sponsors going to have to start putting provisions in all their contracts that are requiring the other contracting party to attest to this?
Correct. Yep. I think that that's going to ultimately be the solution.
That'll be fun.
Mm-hmm. Yeah. I see we got another question. What happens if you don't attest? There could be enforcement action. So we're working on that, and we're working on sort of how to handle that. There's not good answers. I have been a professional banger of my head against the wall on this issue for the past several weeks, trying to come up with good answers. And tune in to the MCQ webinar in the next week or two. Like, it's going to be sometime in the next 2 weeks. We're in the scheduling process right now, and hopefully by the time we do it, I will have more cogent thoughts on it. I promise I will. I don't know what they will be yet. I'm still working on it.
You got to tune in to find out.
Yeah, right.
The
I'm not holding out on you.
Go.
I haven't figured it out yet.
More to come. Scott, you got any brain stimulating questions for closing this thing up, or?
No, I just want to thank Jen. I mean, every time I spend any time with her, I always feel way smarter. And so we greatly appreciate your time.
My pleasure. I was happy to be here. Thank you guys for the invitation.
You bet.
I don't think you've ever said that about me before.
No, I haven't. It's kind
we
of
spent a lot of time together. Oh. All right, I'm going to come up with something that's going to dazzle you. Danielle, you want to throw up the closing slides here? There we go. So
got it.
Jen shared her contact information. Feel free to reach out to her or Scott and my information if you're so inclined to say anything nice to us or have questions. And then do we have a November kickoff slide for Dave Chase? Is that on here, or should I just do it verbally?
It's going to need to be a verbal one this month.
Going with the verbal route. All right. So our November Fireside chat is going to be Wednesday, November 15th with Dave Chase and Health Rosetta. So keep your eyes on your inbox. Those invitations and registrations will be coming out here shortly. as always, this recording, as with all other Fireside Chat webinars, are available on our website for your viewing pleasure. I think there's 3 years of banter on there that you can go back and watch. Some really good information in there. So just go through, peruse, and enjoy yourself. Other than that, I appreciate everybody's time jumping on here. It's great to see the continued following, and hopefully we're providing some information that brings some insight to things going on in the industry. So Jennifer, thank you so much for your time. Appreciate it. And everybody tune into her podcast and webinar to learn more on other things, gag orders and everything else you got going on. So
Gag orders, gag clauses, whatever.
Yeah, all those fun things. All right, guys, take care. Signing off.
Be well.
Bye.